Now, India has hit the reset button on its labour laws. 4 new labour codes are now in force, which represent the most significant restructuring of India's labour laws since independence. But what exactly triggered this major overhaul? The existing labour laws were decades old, some dating back to 1930s and 50s, patchwork of outdated rules that made compliance complex and inconsistent. With economic reforms and the push to make business easier, it became clear that a modern, unified framework was in fact needed, something that could simplify rules while protecting workers across the country. So what exactly do the new labour codes cover? They consolidate 29 old laws into 4 codes. The codes on wages, industrial relations, social security and occupational safety, health and working conditions. And unlike the old system, they cover everyone, formal, informal, gig workers, aiming for clarity and inclusivity. But what does this actually mean for the stakeholders? Under the new code, minimum wages are now guaranteed for all. Appointment letters are mandatory. Social security is extended to contract and gig workers, as I mentioned earlier. Workplace safety and women's rights are strengthened, and compliance is much simpler with a single license and return system. But not everyone sees this as straightforward progress, as is the case mostly. Critics point out a few sticking points. MSMEs worry about the high cost of compliance. Workers worry about the transition period itself could affect salaries, job terms, contract stability, and some feel union and collective bargaining rights have been weakened. Even with these laws in force, challenges remain on the ground. Center-state coordination is still ongoing. Many workers remain unaware of their new rights, and enforcement infrastructure needs strengthening to ensure a smooth rollout. And that brings us to today's discussion. Are these reforms truly going to transform workplace rights, or will the challenges of implementation dilute their impact? So we're going to discuss this, of course. Joining me today on the Breakfast Club, Sumit, Chander, lawyer, Supreme Court; Nurul Hassan, executive partner at Lakshmi Kumar and Sridharan attorneys. Thank you so much, both of you, for joining me on the Breakfast Club this morning.
Thank you so much.
All right, Advocate Chander, let me just come to you first. We'll quickly go through the major points on this first. What do you think has triggered this revamp? As I mentioned, the earlier framework perhaps seemed more like a patchwork. Why do you think this was triggered now? And also to that, why did it take so long?
The reforms always take time. There's nothing wrong with that. But the question is, should those reforms happen? Yes, delayed, could have been done much earlier, but now that it has happened, I think it was long awaited. I think this should have come much earlier, but at least now it has come, and it's a very important reform. Like you rightly pointed out, 29 separate labor laws, all overlapping with each other in some places, certain important issues getting overlapped. At least now we have something which is standardized, fixed, and that should be helpful for both the industrial as well as the laborers. And not only it's 29 separate labor laws, what you're also looking at is the 1400 rules under these laws that were there. So possibly now things should consolidate and make life easier both for the industries as well as for the workers.
All right, and to that, Advocate Hassan, let me come to you. What's your take on this? What do you think took so long?
So I hope I'm audible. So you would require a reform to be taken up. It will take little time for the government to also stabilize, and there will be a lot of consultation that needs to happen before any reform is introduced. Okay, the laws have been promulgated sometime back in 2019 and 2020, but it took some little time for everyone to absorb and kind of understand what is there in the labor laws. I think it's also the government's initiative that it has taken now, probably never late for the implementation of a reform like this.
Right. So, do the 4 new codes genuinely simplify compliance? Because there are, of course, a lot of concerns, as is the case when anything new is introduced. So, would you say that maybe in ways this may have merely repackaged complexity, or do you think this has to a large extent simplified compliance? Advocate Chander, let me come to you on that.
See, like I pointed out earlier, there were certain overlappings in certain places. Then the IT industry came in much later after the old laws came into existence. So that is why, and the women working in the industries, all these protections, these needs, I think evolved over a period of time. When the problems evolve over a period of time, it becomes necessary for the reforms to come in. Now, as pointed out rightly by my learned friend, that once a reform is introduced in the parliament or suggestions are called for from all the stakeholders, so these discussions take time. And I think after a lot of thought, after a lot of practical approach from both the aspect of the industries as well as the workers, they finally came up with some law consolidating it and simplifying. For industries, simplifying one registration, one license, one return, and other aspects. For laborers and workers, I think to a great extent, a lot of things have been consolidated in terms of their pays, their gratuity, PF, enforcing whatever the laws were there earlier. Now enforcing them practically here. Once the laws are simplified into certain codes and smaller codes, it becomes easier to implement. So I hope with these new laws, the implementation should also become better. So it will help both the industries as well as the workers.
Right. And Advocate Hassan, with these guaranteed minimum wages for all, how do you think that will translate? Do you think that will mean high incomes at the ground level?
Certainly, I think the government has brought in the new concepts like floor wage, right? So the floor wage is going to be set by the central government, and it is going to be the benchmark for all the minimum wages for each of the states to follow, right? The minimum wage is therefore is going to be set at least at the floor wage. So thereby, lot of gaps in terms of the minimum wages across the country is going to be stabilized, and you will have a much visibility as to even for the employers to follow in terms of the minimum wage and therefore of the floor wage concepts.
Right. Now, of course, when we talk about these structures that have been brought in place, there's this very real question of enforceability as well, and how effective that is. We have heard and we are seeing some of the changes that have been brought for women workers as well to strengthen the infrastructure surrounding that. That being said, how do you see it being enforced, and what are some gaps that still do remain? Advocate Chander, let me just come to you.
See, like I said, once you consolidate the acts, there's less overlapping. Once there is less overlapping, things are much more clearer as to what needs to be implemented and how they are to be implemented. When you do this, first thing you remove, because of the 29 different laws with more than 1400 rules, is the power of the what we used to call the Inspector Raj, who would come, use some law, some old act, some provision they would come up with and then try to enforce in a manner just for personal gains. Those things now with much more clarity and lesser codes will now not be possible and that Inspector Raj, which was there earlier, would now and should disappear. Now, because the compliances become less complicated, the compliances should take place. Like I said, now there are lesser, only one return needs to be filed, things need one license required for various things. So all the compliances, once you simplify it, it encourages people both for the industries as well as for the employees to ensure that the compliances are done, and not only done from their part, but also ensured that they are made more effective. So I think it's a good move, and let's see how the implementation finally we'll get to know when it practically comes down on the floor.
It really just all comes down to that. And Advocate Hassan, what's your take on this as well? How do you see the issue of enforceability? Now, what Advocate Chander is saying, once you consolidate the acts, once the rules are clearer, once there's no overlapping, that sort of irons itself out. What's your take on this?
So there are a couple of things here which we must know. Firstly, as my learned senior has specifically said, the abuse of the inspection regime is going to be done away with to large extent, because the chief inspectors are going to be now treated and called as chief inspectors cum facilitators. So they are going to be ensuring the facilitation of the implementation of the codes. So to that extent, a lot of kind of facilitation is going to be given to the employers. But having said that, are we also going to have some kind of a conflict? Yes, because the Labor and Employment and the Shops and Establishments Act are going to be also there on the statute book, because shops and establishments are going to be treated and governed by the provisions of the state list. States will be making the respective legislations, and therefore when a kind of a overlap comes in, thereby you will have certain kind of a rift and conflict between the new labor codes and the Shops and Establishments Act of the respective states. But having said that, I think the jurisprudence seems to be clear. Like you will have to implement which is more beneficial to the employee or worker. So even if there is going to be any overlap, that's going to be ironed out by making or giving more weightage to the benefits of the employee or the workers. So thereby, I think it's going to be a good situation for both employees and workers.
Right, and are gig workers truly gaining social security? What do you think of that promise, Advocate Chander?
See, earlier the wages were separate, EPF, ESI, bonus, gratuity, everything was separate. Now, what they have done is now the new laws combine everything under the definition of wages itself. So now when you say wages, it includes already all the things, all the benefits that were earlier given. With these kind of simplifications and I think the way this has happened, not only the gig workers, I think all employees in general would benefit from this.
All right. And Advocate Hassan, in what ways does the consolidation of laws strengthen workers' rights, or does it dilute union and collective bargaining power, something that remains a big concern as well?
I don't think so, considering, earlier under the Trade Unions Act particularly, there is no mandatory provision for the recognition of the trade unions by the employers. Right now, under the new codes, there is a specific mechanism that have been carved out in which you have to recognize the trade union. Right? Of course, you will have the ways and methods which is built out in the Industrial Relations Code as to how the trade union has to be recognized based upon the representation of the employees or the workers in the respective trade union. But yes, it is going to be the employers have to recognize the trade unions, which now we call it as negotiating trade union or negotiating trade council, basing upon the representation of the workers in the respective trade union. I think we are going to recognize more and more trade unions as part of the collective bargaining mechanism.
Advocate Chander, why do you think there are such concerns surrounding this as well? Because a lot, as I mentioned in my question as well, some do see this as perhaps diluting the collective bargaining powers. Do you think that's perhaps lack of awareness, and what's your take on this?
See, I mean, of course, they're both sides of the story. Though now the unions are recognized, now what their law also has provides for that earlier you could go on strike on immediately or whenever the workers would decide. Now the labor unions would have to give a longer notice period. That would give more time for the industry to take care of whatever the situation is, possibly settle it also. Not only this, there is an expanded prohibition during the conciliation period. So now they are mandatorily, during the conciliation period, they are prohibited from doing otherwise the acts they would have done, which earlier was possible. So there are basic, both the advantages and disadvantages are there. Like my learned friend pointed out, the notice period, the unions are recognized. That's a huge advantage. The negative, if I may say, would be basically the notice period or expanded prohibition during the conciliation period. The tribunal proceedings have now, been more regulated. So all these things have their own advantages and disadvantages. But I would say it is an overall need for the society, for both the benefit of the industry as well as the employees, that this provisions do come into existence. So nothing wrong with that. But yes, anytime anything new comes, it will have its own advantages and disadvantages. I think it will again boil down to how it's implemented during on the flow with time.
Absolutely. Every time something new is introduced, it's also going to face its fair bit of resistance. That being said, there comes the mammoth task of center-state coordination as well. So what mechanisms, if you could just explain to our viewers, Advocate Hassan, first you, are perhaps in place to ensure states do implement the codes uniformly and without any delay as much as possible?
If the news reports are to be believed, the take from the Joint Secretary from the Ministry of Labour and Employment has to be considered. Then what is happening is that all the 4 labour codes, barring few states, have introduced the state-specific rules already, right? That's the first thing. Of course, it has not been published in the official gazette. We have to wait and see how they are going to be doing it. Secondly, the central rules have also been introduced, and now the government expects a public consultation, and it is expecting all the state legislatures or the state governments to bring the or republish the rules once again of the respective states, so that the public consultation can take place. Now they are likely to give 45 days time for the public consultation once the rules are going to be kind of introduced. And then thereafter, another 45 days time is what the government is likely to take for the overall fine-tuning of the rules based upon the public comments. I think this is how the rules are going to be implemented or notified soon. But I think the center and states have to work in tandem to bring out the rules. I know there are a couple of states that have not yet introduced any of the rules, like West Bengal. They have not introduced any of the rules. And states like Gujarat have already notified some of the rules, for some of the codes. I think a public consultation or a proper consultation between the center and state is probably necessary at this point in time, so that at least the workers or the employees and the employers will be in a much better position to implement the law.
Right, Advocate Chander, do you want to add to that?
See, it's very simple. I mean, if the laws are for the benefit for both the industries as well as the workers, I think every state government would participate and should participate, in fact, to make the rules as practically required for their states. The basic laws the central government has come up with, like I said, they have thresholds and other limitations they have put, which will have to be a minimum wage and things which will be now the central government has notified. The state government, through their rules, have to just tweak it to suit the needs of that state and their workmen and their issues. So they will have to do a consultation with both the industries as well as the worker unions, and finally the rules will have to be made out. But I think it should and would get implemented, because these laws are long awaited and need to be implemented for the benefit of the society at large.
Absolutely. And just to expand on that, Advocate Chander, how will the transition period impact existing employee contracts, salaries, their job security? There's a lot of uncertainty regarding that as well.
True. And those uncertainties, again, like I said, would take time to get ironed out. And that is where the coordination between the government, the states, needs to be taken into consideration. And I'm sure it's all a matter of time. At least things have started, a big step has been taken, and now we just await the implementation of that.
All right. And Advocate Hassan, are companies truly ready for digitized compliance systems, or do you think that's going to be a mammoth task as well?
I don't think so, considering most of the companies, I'm not again commenting on the small and medium enterprises, but large enterprises by and large have digitized most of the records, information, and so on and so forth. But with reference to the MSMEs, again, when you go to any MSME or medium sector enterprise, you will still see the visitors registers maintained in the physical form, and you have to make an entry there physically. So the physical records are going to be there, but an option is given to the employers to kind of ensure that their records can be digitized. So this is an opportunity even for the employers to kind of digitize, and in fact the code also says the payments have to be now made digitally to the bank accounts of the respective workers. So I think this is an opportunity, I would say, for the for all the employers to digitize their records, and also ensure making the contributions and also making the payment of wages to all the workers categories in digital form.
All right, and Advocate Chander, just before we let you both go, how do you think enforcement agencies will be able to upgrade capacity to monitor compliance across India's vast informal sector as well? That's a big thing.
That indeed is a big thing. In fact, now trainings, of course, will have to be given. Since the new laws have come into place, the compliances have, in a manner become upgraded. I would say it has not changed. They have already been doing this, but the way, like they rightly pointed out, now they are not just the enforcing agency, they are also facilitators, as the name has been given to them. So let's hope how they are trained and how they implement, end of the day will boil down to how it works. But yes, things are in place, and let's see how it works. But it's in the right direction. It's a way forward, and I think this was long awaited. So let's see how it works.
All right, and Advocate Hassan, let me just come to you on that as well. Do you want to add anything to that?
As of now, I see there is a lot of gap in between the awareness, because the government has suddenly brought the labor codes for the as far as and notified the labor codes, and therefore the employers took it as a shock, and they are trying to absorb this, and the rules are not in place, and there is a lot of misinformation which is also flowing out. So actually the government has to take a public consultation here, okay, and also sensitize and educate and create awareness programs for the employers and also employees and workers. Immediately there are a lot of questions that are being thrown out, whether gratuity is going to be an issue. So gratuity is if and how wages have to be computed. So if clarifications in the form of FAQs are given by the ministry, then it's going to be a lot easier for the employers to cope up with. Otherwise, it's going to be a task which they may have to do it with a lot of vacuum, and leaving it to the lot of interpretation and ambiguity. I think a lot of FAQs, public consultation has to take place here.
Absolutely. All right, Advocate Chander and Advocate Hassan, thank you so much for joining me on the Breakfast Club this morning. It was great talking to the both of you. Perhaps our viewers are able to understand this new labor revamp a lot better now. Thank you so much.
Thank you.